Well, let's get more on this now. Professor Ben Cousins is Professor Emeritus at the Institute for Poverty and Agrarian Studies, PLAS. He's an expert on land. Professor Cousins, good afternoon to you. Thank you for your time. These courts would have certain powers to adjudicate these claims. Is it that big a change from the system of land claims, the system we had in the past?
Well, it's an important change, Stephen. I think boosting, strengthening the capacity of the courts in respect of land is absolutely necessary. The old land claims court did not have permanent judges. Often they were temporary or acting judges in charge, and the whole area of dispute resolution has been gravely neglected. The land rights management facility has been a farce for many years, so it's very, very important, in fact, to strengthen our capacity to resolve disputes. That's inherent in land reform. Land reform generates disputes and conflicts, and you have to have a way of resolving, and particularly so when many of these laws and rights derive from the Constitution. However, it has to be said very strongly that this is not a silver bullet, as the Minister himself said. It does not resolve the major problems facing land reform. And while they're absolutely necessary, they are very, very far from sufficient, I must say.
So I'm going to come to that in a moment. I mean, in the past, the process of lodging a land claim, the adjudication of it, it was incredibly complex. I think there were over 100 steps in the process. That would slow things down. It would allow someone to dispute every step. I imagine this process would be quicker than that.
Not really, Stephen. You need to, if you want to change the process, you have to change the law and the regulations. You have to engage in administrative reform. This bill will not affect any of the other laws of land reform by itself. I mean, land restitution has become a major disaster area. We have no notion, no figures have been released for the last few years about how many outstanding claims there are. And if we take into account finalization, the implementation of claims rather than their settlement as such, it's probably still around 20,000 claims. And the only way to resolve that huge logjam is through radical administrative reform. And that's what's required. Of course, it's good to have a court. It's good to help resolve the disputes and the many other positive features here. But in itself, it does not release that logjam.
So when you talk about administrative reform, you made the point that this inherently leads to disputes. The people who currently on the land now have rights. The people who are dispossessed of the land have rights. The people who want the land have rights. Those are generally the same people or related to each other in some way. I mean, what kind of administrative reform would create a situation that could remove the dispute? I can't imagine removing the dispute is really possible.
No, look, Stephen, government has created many problems in the way that it has set up the system. And I saw one report today which quoted the minister as saying one motivation for introducing this is this new court bill is to avert the bundling of claims into dysfunctional mega claims, which in turn generate conflict. And here it's a little bit mysterious, but what he's referring to is a very negative practice engaged in by the Commission for the Restitution of Land Rights over the past 10 to 15 years, which is to take a great many individual claims, that could be individual community claims or by individuals, and bundle them up into vast mega claims, which actually create more problems than they resolve. And somehow there's a little signal going on here that government is trying to rethink that practice. Now, what's required is to think through the restitution process, avoid the bundling of claims, and to engage in fine-tuning so that the whole process is more efficient. That must include strengthening the capacity of the Commission, in particular strengthening its research capacity, and I would suggest also firing the Commissioner, who's proved to be very, very ineffective, and putting someone else in charge.
Sure, that's quite a strong view. What we kind of want from this, and I don't know if this is possible, is some kind of inherent fairness. All the people involved, whether they be the people who are claiming the land or the people who currently own the land, would want to come away from a process at least feeling heard, at least feeling part of the process, at least feeling that their point of view was taken very seriously, whether they prevailed or whether they won or lost, or whether they got compensation or they didn't. I do wonder if that's actually just too much to ask, given how difficult our history actually is. This was, the violent dispossession of land.
Well, look, I think questions can be asked, certainly I've asked them in the past, about in retrospect, whether it was wise to embark upon land restitution, because this is such an inherently conflictual process. But if we put that question aside, I think also some things signaled by the Minister, there's going to be a role for the court in pre-litigation processes, trying to mediate or perhaps seek arbitration before processes get to the courts. There's a tremendous potential here to clog up the land court with innumerable disputes. And here what's, a very significant change being introduced is to dismantle the land rights management facility and to ask the Legal Aid South Africa to, that was a facility set up by government, but usually involving third parties, law firms and so on, to investigate disputes and try and resolve them before they get to court. Now Legal Aid South Africa is going to be tasked with those kinds of processes. And here I think your point, Stephen, about people having a chance to participate actively, and not in a court where you have to be represented by lawyers, which costs a lot of money, but in non-traditional conflict resolution processes. That is, trying to get together and talk it through. That creates real possibilities. I think there is a question about whether we're not asking Legal Aid South Africa to play two contradictory roles, because legal aid is partly there to provide people with access to the courts without them paying large sums of money, which they don't have. Are they going to continue to play that role with respect to land disputes, or are they going to, are they going to be put in a situation where there's a conflict of interest? On the one hand, they're mediating. On the other hand, they're supposed to be providing resources to people who don't have them to enter into these processes. So there is a question mark there. But I think generally, early on in the land reform process, in the early 90s, it was recognized that mediation, arbitration, conflict resolution was going to be absolutely integral. The department was set up with this function in mind. It was outsourced, but it's never properly worked. Now at least government is trying to seize this issue and create a more robust institutional framework. It does have potential, but I think along with it has to go deep-seated both administrative reform and a thinking through of policies. The policy framework is itself still highly problematic, and we haven't heard that much about policy reform in the last year or so.
Professor, it seems to me, the land issue, I think, will almost always be with us. Because it's so difficult to resolve. It seems to kind of come and go. I don't mean that it goes away. I mean that the temperature, if I can call it that, the political temperature goes up and down. 2 years ago, coming out of the ANC's Nasrec conference, we were all talking about land all the time. Even before the pandemic came, it seemed to ebb a little bit as an issue. Now it's starting to come back, perhaps. Do you think that 100 years from now, we could still be having this debate? Do you think things will change? I deliberately won't use the phrase, will we move on, because I don't know if we can.
Personally, I think the land question doesn't go away. It seems to go to sleep for a while and then it wakes itself up. It's why I think it needs to have higher political priority and not be used simply as a political football between factions of the ANC, but taken seriously by society. I think we do need to move on this. That will require more commitment, a bigger budget, building capacity, all these things that we've been talking about for many years. It doesn't go away. One positive thing about the new court bill, Stephen, is that it's set up to have jurisdiction over all aspects of land and land reform, including tenure reform, the thorny issue of the powers and roles of chiefs in respect to land, and land redistribution. And explicitly, of course, a referral here to the expropriation issue, in addition to restitution. So that is itself a very positive thing. And it signals that, what I think it indicates is a direction I think government should go in, which is to think holistically about land reform. Not see there's as 3 separate sub-programs, perhaps with a 4th called land administration added on, but rather see them holistically as a bundle of policies which are both urgent, have to be streamlined, have to be brought into alignment with one another, and that itself might require a new overarching piece of law brought into being by Parliament to guide land reform as a whole. This has been signaled by both the Motlanthe high-level panel and by the presidential panel. It hasn't been spoken about since Minister Didiza has come into office, but I think that is a much more urgent piece of legislative reform, something to guide the entire process in a coherent manner, bring the parts into alignment with one another, and proceed with dispatch.
Professor, I really do appreciate the time. Thank you. Professor Ben Cousins is Professor Emeritus at the Institute for Poverty and Agrarian Studies, PLAS, at the University of the Western Cape.